Hello, everyone. My name is Erika Stillabower, and I'm probably a familiar face at this point, and Hope Todd is joining me as well. We are both from the DC Bar. Hope is the head of the legal ethics program, and I'm one of the ethics counselors at the DC Bar ethics program. And of course, we have Rashee, who I know is a familiar face to all of you as well. So we are here, I think this might be the final event of Ethics Week. Is that correct, Rashee?
Yeah, it is.
So
you are the closer.
I'll congratulate all of you on hanging in there. We hope we'll give you an entertaining or at least an informative hour and get you some ethics credit as a reward for hanging in with us. I know that many of you have seen us present before, and this will probably look very familiar. Hope and I love to teach ethics using hypotheticals. And the hypotheticals, of course, are intended to help us get into the rules. And they really mirror and reflect the types of questions that Hope and I answer on the ethics helpline of the DC Bar, where people cold call us and say, I have an issue, and they throw out some facts, and we try to weigh in and give them the best advice we can based on the rules of professional conduct that govern DC lawyers and any ethics opinions or other practical guidance we might have. So we invite, as always, you to participate, whether that's throwing up a contrary point of view or some alternative facts that you would like us to take into consideration, or feel free to press us. We're always happy to take on adverse opinions. And also, you'll see in the hypos that we have, there are different ways to approach them, and just a little bit of a change in the facts can really change the outcome. And we'll be trying to discuss that with you as we dig into the questions. And of course, as we don't have actual polls set up, so in order to encourage participation and give the three of us feedback in terms of figuring out how to address our analysis with you, we do hope that you'll all participate in the polls or in answering the hypotheticals by putting your answers into the chat. So, an A, B, C, or D. That just helps us see where things are trending and what got people's attention and what they were either overlooking or what they were grabbing onto. So please do participate. And that said, come on, if you could advance the slides. I think go right ahead to the next one as well. That's great. So we always like to highlight the resources we have through the DC Bar for the legal ethics program. The legal ethics section of the DC Bar website is full of really good guidance. It's got the rules of professional conduct. It's got the ethics opinions listed in reverse order. They're searchable. You can look for a particular rule on the ethics page and find what ethics opinions we have that address that rule. Of course, we have the confidential ethics helpline that Hope and I are staffing. We also have Saul Singer and Nakia Matthews, both of whom are out temporarily. And we have other resources, such as articles that the Ethics Council have written addressing various ethics issues. And so we would encourage you to take a look at that if you ever have some questions or need to do some research on an issue. I was just on the BEGA website, and I know that they have a pretty substantial set of resources as well that help answer questions and provide guidance and direct you to various resources if you're trying to muddle through an issue or figure out if you have a reporting obligation. So we would encourage you to take advantage of that. Kavan, you want to advance the slides again? Great. So, as I've already mentioned, the DC rules govern lawyers who are admitted to practice in DC. And in fact, they follow lawyers that are admitted to practice in DC, even if they happen to be doing something in Maryland or across the country. So there is a complicated choice of law analysis that helps DC lawyers figure out what set of rules they're going to be subject to for any given conduct. That is something that we could spend hours on just as a single rule. So we're not really focused on that today, but that is always something to keep in mind, right? It's
we will have one hypo that deals
okay.
with it, so we'll get.
Oh, you're right. You're right. Okay. the may, should, or shall language. This is just a really interesting aspect of the DC rules of professional conduct and the model rules as well, right? Some of the rules create a hard floor or a hard ceiling. You know, your conduct cannot exceed this level or cannot fall below this level. Other rules really take more of a prudential approach, right? A lawyer should or ought to. And then, of course, there are some that are really purely aspirational. You know, it's a best practice, or ideally a lawyer would do X, Y, or Z. These are really important considerations when you're trying to figure out what you must do or what you can't do or what you can consider doing. So always keep in mind that aspect of these rules. And of course, the idea of these rules being rules of reason, again, that's a really essential part of the ethics rules. And you'll notice in our ethics opinions, they often start with that when they take a hypothetical issue and you start by thinking, well, what's really happening here and what's an appropriate outcome given the basic framework of ethical obligations for lawyers. And sometimes, you know, it's very helpful in interpreting an ethics rule because you can look at guidance in other rules that are maybe not directly relevant, but they still inform the approach that Hope or Saul or Nakia or I would take in evaluating an issue. So let's go ahead and go to the next slide. And of course, you always have to remember, this is particularly important for government lawyers who are subject to the rules that govern government employees, right? DC employees have their own set of rules and limitations that they're subject to. The ethics rules that we're focused on today exist in a larger legal context, you know, and so in addition to the DC government rules, court rules, federal, state law, all govern your conduct and you're responsible for following those laws when you take an action. So substantive law may guide or dictate your ethical conduct. There are direct references to substantive law in the ethics rules in different areas. And of course, sometimes the substantive law does not directly align with the ethics rules. And in that case, you know, generally the thing to do is to follow the most restrictive guidance. Of course, if you are dealing with a situation where you believe you have a duty of confidentiality and you get a contrary order from the court, or you are subject to a law that says you must disclose, you're going to do that. And that exception is actually built into our Rule 1.6 on confidentiality. But that's just one example of, you know, situations where lawyers really have to be thinking about multiple levels of restrictions and obligations from other sources of law. So makes things a little bit more exciting. Next slide, Yvonne. All right, so here we are into the hypotheticals. Hope you're going to start off, right?
Yeah. Well, I think I'll tee them up for everyone and then into the meat of the discussion. So our first hypothetical, we have Ron, the prosecutor in the Office of the Attorney General, and he works on cases involving tax fraud. He was recently asked to serve on the board of Jacob's House, a nonprofit that focuses on affordable housing for DC families. May Ron serve as an unpaid board member? What do you all think? If you could just put your answers in the chat function. A, yes, because he's not being compensated. B, yes, because serving on a board is not legal work. C, yes, but he must comply with the laws and procedures regarding outside employment and DC government employees. Or D, no, because it could potentially conflict with his work as an OAG prosecutor. So I see a bunch of C's are coming in. Pretty consistent here. Anybody have any? Not C.
No, there's a D.
There's a D. And I guess I should say, thank you for having us come. We always enjoy coming to speak with you all, and it's a privilege for us, and we learn a lot. We probably learn as much from you as you learn from us. So it's we're really glad to be here today.
It's true.
All right, it looks like we have a consensus around C, Erika.
Yeah,
so
that's good. C is the answer we were going for. It is the best response here. So if we can skip ahead, I'll get into the analysis quickly of how we arrived at C and what some of the red herrings were. If we could get to the next slide. Perfect. So the first two options really didn't catch much attention. So the lack of compensation is really irrelevant for purposes of evaluating the ethics rules, right? Pro bono lawyers, whether they choose to be pro bono or forced into being pro bono because their clients won't pay, are in the same boat with respect to their ethical obligations to their clients or to their employers. So, you know, compensation just is really neither here nor there as when we're talking about how the ethics rules apply. The fact that the work is non-legal, it certainly changes the analysis a little bit because conflicts of interest, you know, et cetera, typically arise when you're engaged in legal work, except there is one very important conflict, the personal interest conflict, in which a lawyer's lack of legal representation doesn't matter. A personal interest conflict describes the situation in which a lawyer might be tempted to pull punches and not be a diligent and zealous advocate for his client because of a personal interest, whether that's an outside job or outside volunteer work or a family relationship. There's a million different ways that a personal interest conflict can arise. So that's really not the issue. And the other sort of red herring we built into those answers was D, which is the fact that this outside work could create a conflict of interest for him as a OAG prosecutor. The fact that a conflict could arise is sort of a fact of life once you are a lawyer and a member of a bar, right? Conflicts arise all the time, not necessarily through any fault, more in fact, almost never through the lawyer's fault. And the lawyer's job is simply to act appropriately in those circumstances. A lawyer is not obligated to stay home for the rest of his life to avoid getting into conflict situations outside of his house. Option C it is. You have to comply with the laws and procedures regarding outside employment and for the DC government employees. And you know, this is a chance. I don't know, Rashee, if you have any thoughts on this that are worth diving into right now.
Just real surface level, like you could think about it in the same way you think about outside employment. Like, does it affect how you do your DC government work? Are you using DC government resources? Are you using non-confidential information? And so far from the hypothetical, it seems like it's okay.
Yeah, I think that makes sense. When I was looking at some of the kind of the bullet point descriptions of the limitations imposed by DC, one of them that just caught my eye because I thought it was interesting was that it could interfere with, if your outside job would interfere with the efficient administration of government. And in the legal context, what I was immediately imagining is just a situation where a lawyer decided to do something, you know, in a volunteer role, but it caused him to have to recuse himself from a whole bunch of legal representations that he was doing on behalf of the District of Columbia, right? It's like, okay, we can only keep excusing your conduct or putting other attorneys in to handle this responsibility in so many, you know, on so many instances. So that one was just an interesting one that jumped out at me. Let's go ahead and get to the next hypothetical.
Okay, next slide, please. All right, next hypothetical. Ron secures the necessary approvals to serve on the board of Jacob's House. At the third meeting of the board, a new board member is introduced, Corilla Hemsley. She's a real estate developer who's deeply committed to meeting the housing needs of district families living in poverty. Ron knows that OAG has been conducting a years-long investigation into her business, which is suspected of avoiding taxes on over $300 million in income. Is this a problem for Ron? A, no, so long as Ron screens himself from the investigation. B, only if Ron has supervisory authority over the investigation of Corilla Hemsley's business. C, no, so long as Ron and Corilla avoid discussing any aspect of the investigation. D, yes. What do you all think? Everything says this is a problem.
I think I saw one C in there. There's
Oh, I see 1A. I have
some
an
A's
A,
and C's.
some C's. D. Okay.
This
Yeah,
is great. And this is kind of an interesting, I think Ron should have joined. That's always safe, right? Just keep it out of the district. So this is actually a really interesting hypothetical, and well, let's skip ahead. The answer that we were aiming here is D, and I just see this comment here. D is safe, but could use more facts, and that's what we're going to get into. So this happens to me quite a bit on the helpline, on the ethics helpline, where someone will call up and present a hypothetical, and I'll kind of go off on a tirade explaining my concerns, and then the facts will change. I think, okay, let's pull back on that. But here, my initial thought upon seeing this is this just, this just looks like it could be a big problem, right? Whether, you've got somebody who seems to be a significant target of the Office of the Attorney General, working closely with an OAG prosecutor who might not be the person actually prosecuting that matter, but it's
in the tax division.
in the tax division, right? I mean, we could draw parallels with other, real life public people who are being investigated by various entities, and the idea of these people who seem to be at loggerheads and their battles are playing out daily in the headlines. The thought of them working together on a lovely nonprofit it just seems really incongruous and hard to imagine. And as if at some point someone could question, well, let's say Ron decides he's not going to prosecute Ms. Helmsley after all. Does this mean that there was some behind the scenes, backdoor business going on at this board? Who knows? It just looks strange. So my first thought would always go to, this is a 1.7 issue, and that's a personal interest conflict, right? It's a punch pulling conflict. But these are waivable conflicts. It's just that I'm not the person who can waive it for anyone. This means you have to go back to your client, which in this case would be the Office of the Attorney General. You have to take it up the chain. And if we could skip ahead one slide. This is the waiver provision for a personal interest conflict in any of the punch pulling conflicts under 1.7b. It says there's two prongs, right? I actually always like to start with the second one, that the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. In this case, there's only one affected client, but you have to believe that you can, despite this issue, I can do this work. And then the second prong is this paragraph 1. Each potentially affected client provides informed consent to such representation after full disclosure of the existence and nature of the possible conflict and the possible adverse consequences of such representation. Now, one thing I always wonder about is, when I tell a government lawyer, well, you need to get permission, you have to get a conflict waiver from the Office of Attorney General. I'm always curious as to whether one actually gets a waiver of a conflict, or if the government reviews it, a senior attorney at OAG and says, this doesn't concern us. We have no problem. We don't see a conflict here. I think either way, the lawyer has successfully or reasonably fulfilled his responsibilities to get a waiver, even if the government's position is we have no concerns with your serving on this board. So the other thing I wanted to mention, though, right now is we had some people who were kind of gravitating towards other answers to this hypothetical, such as the fact that, well, it's okay as long as Ron screens himself, or only if Ron has supervisory authority over the investigation. These are possible responses that could mitigate the issue. So for example, if Ron goes to the government and says, well, how about if I'm not overly concerned about this, but in any event, I think the concerns could be moved down to 0 if I were to screen myself from this representation. Certainly a lawyer in Ron's position can agree to do that. The other thing that happens sometimes with these calls is I presented a hypo, and I was trying to present a hypo in which this looked like a serious and intense potential conflict of interest here. But the truth is, there are other facts that could make a difference, such as maybe Cruella Helmsley actually has been acting in good faith, and she's a developer who does a lot of projects in Maryland and DC, and there is significant confusion over a 10-year period, but what jurisdiction she was supposed to be paying taxes to. But she's paid a significant amount of money, maybe not to the right entities, but it was certainly acting in good faith. She's been cooperating in the investigation. She's not this villain that my hypo initially made her out to be. And then furthermore, maybe, the attorney general and 3 of his top deputies are separately serving on different boards with her, right? The lawyer tells me that, again, I'm going to say, okay, again, maybe this is not such a big deal. Maybe there's a lot of facts here that say this is probably a big nothing burger. Again, I still can't be the one to waive it for you. You still have to go back to the Office of the Attorney General and take it up the chain to make sure that you're getting appropriate guidance, that other people agree with your assessment that you should be able to go forward with this board position.
So Erika, there's a question in the chat.
Oh, good.
Speaking of the client, I know there's a subdivision of a rule about our client as government attorneys being our agency, and that's right. That's DC Rule 1.6K that says the government lawyer is the agency. The client of the government lawyer is the agency in which the lawyer works. But then the comments sort of go on to explain that sometimes substantive law will dictate exactly who the client is in those circumstances. But the question goes on to say, being our agency, but what if we serve an agency within an agency? Do we have informed consent from only the top entity in the chain, and more generally, who's our duty of loyalty and confidentiality to, et cetera? Well, the duty is always going to run to the identifiable client. The hard part of the analysis is identifying the client. And you aren't going to like this answer, but the ethics rules do not identify the client. They do for purposes of confidentiality under Rule 1.6K, but they also are clear that if the law provides otherwise, you got to follow whatever the law is. And so the answer to that question is, ideally, within agencies of government, you have identifiable people who are the whoever it is, the buck stops here, to give the informed consent. Whether, it's a secretary in a, the secretary of whatever agency, or the mayor, whoever it is within the chain of command, hopefully within your agencies, there is someone identifiable. And to the extent you don't know the answer to that question, you might want to go back to your offices and see that gets developed. And it may be the person ahead of you who's the one that's responsible for actually, clearing the consent. Rashee, do you have a better answer than that?
Unfortunately, no. That's the same advice I've been previously given from the Mayor's Office of Legal Counsel is, that the agency is your client. And that was more in terms of, if somebody in the agency wants you to represent them personally.
Mm-hmm.
Right.
Yeah, for most purposes, I think that's true. But I do think sometimes you can get into sort of hairy situations where there might be an internal agency within an agency, and there may be some disagreement about what information is appropriately shared and with what sort of consents, which again are going to be dealt with sort of outside of the ethics rules. Although they implicate the ethics rules. So.
Right.
Yeah.
The other challenge is that while everyone's getting along and fully aligned, no one's really focused on the fact that there are potentially more than one entity, and that the clients might actually be separate entities, right? It's when a division suddenly occurs that it becomes real to nail these things down. So in a perfect world, you're going to try to nail these things down ahead of time, just so you know what to do if a split arises.
Okay, next slide.
Yep. So this is just real quick. The appearance of impropriety, I always flag that because it's not part of the ethics rules. It's mentioned in Rule 111, which we'll be talking about later. It is not an ethical standard that lawyers have to abide by anymore. However, I do think, it is a signal to potentially investigate further if something is awry, if you're doing something that could bring or cause someone to say, oh, that doesn't appear to be appropriate, or it carries the appearance of impropriety, right? It's a good message to nail things down. Isn't appearance still? Yes, I believe it is part of, and that's very important, right? Judges are not supposed to do something that has the appearance of impropriety, but it really has been stripped out of the ethics rules. And I think that's appropriate because it is such a subjective standard, and people have, you know, the idea that lawyers are going to be subject to discipline for getting that wrong is a problem. Instead, we have more concrete ethics rules that are, I won't say they're easy to comply with, but they're a little bit more straightforward than the appearance of impropriety.
Specific.
Since when is the appearance of impropriety not an ethics consideration? It's not that it's not a consideration. That's the point I'm trying to make it here, but it's not a disciplinary standard. You're not going to see any rule that says, you know, it is professional misconduct for a lawyer to engage in conduct that has the appearance of impropriety. You know, it's just not workable. Hope, do you have anything to add about that?
Yeah, I mean, that really went out with the adoption of the model rules of professional conduct in the 80s, and DC adopted them in 1991. So as Erika mentioned, the only place we see appearance of impropriety in the DC rules of professional conduct is with respect to government lawyers leaving government service. So I do think, though, in this group, that the appearance of impropriety still remains as something, as a consideration, because it does still exist in the government ethics rules, and so the judicial code. So purposes of your employment, it still is a valid consideration, but you aren't going to be brought up on charges in the DC Office of Disciplinary Counsel because something looks bad.
Yeah. Yeah.
Okay, next slide, please. Okay.
Okay, so are you reading?
Question 3. Yeah, I'm reading this one. Yeah, sorry.
Okay.
Okay, board members of Jacobs House decide to take a more activist approach to DC politics and want to draft and release a statement condemning the district's approach to sentencing youthful offenders. Under the rules of professional conduct, may Ron participate in the process? A, it depends on whether the statement aligns with the mayor's position. B, yes, so long as this does not create a personal interest conflict or a positional conflict. C, no, Ron must recuse himself. D, yes, Ron is not acting in legal capacity when he votes on the board. What do you all think of that one? Lots of C's.
Here, there's a B.
There's a B. I saw 2 B's.
All right, thanks for voting, everyone. It really helps us.
Yeah.
I think I'll just go ahead and this is actually one that I think sort of illustrates a little bit this idea of the appearance of impropriety, right?
Right. Okay. You want to do
Yes, we go to the next slide. So B was the answer that we were looking for. Yes, and you know, again, we're bringing it back to sort of more concrete standards. Would his vote, or was his willingness to participate in the release of this statement, under the rules of professional conduct only, under the DC ethics rules, does it create a personal interest conflict or some kind of positional conflict that would interfere with his ability to effectively prosecute tax fraud in the District of Columbia? And I guess I can't say that it does, but we'll go to the next slide. Look at the positional conflict rule real quick. This is a rule that is not specifically defined in the rule itself. It appears in a comment to Rule 1.7. It's kind of an interesting rule. I'm not sure that the scenario here exactly illustrates what a positional conflict would be, but if you look in the middle of this sort of large block of text, there's a line that says, a conflict of interest exists, however, if there is a significant risk that a lawyer's action on behalf of one client in a given matter, as referred to in 1.7b, will adversely affect the lawyer's effectiveness in representing another client in the same or different matter. And I think that's sort of the standard I'd be looking at. You know, does his participation in this rather public and possibly political statement about law enforcement somehow, reduce his ability to be an effective advocate in law enforcement in DC. Again, that's a question for the lawyer, for Ron to be thinking about, and for the Office of the Attorney General or DC generally to be thinking about. Are we comfortable with having our people sign these sorts of public statements? I also know that DC employees are going to be subject to things like the federal criminal conflict of interest statute, right? Which would say he couldn't participate if there was any sort of financial interest that he had in Jacob's house. That's obviously not the case here, but that's sort of the approach we would take, is that this is probably okay as long as the Office of the Attorney General said it was okay. And Rashee, I don't know if there are any hard and fast rules on government employees making public statements like this.
I mean, if it's in your personal capacity, make sure that that you're very clear about this doesn't have anything to do with work, and this doesn't reflect my employer in any way. But I mean, other than that, nothing's happened yet, right?
Yeah,
that's,
right.
That's the real problem. Not problem. I guess that's a good word.
Right.
Nothing has happened yet.
Right.
Yeah.
People are using good judgment.
Okay, next slide, please.
Okay. All right. And
Okay.
we can jump
Next
ahead
slide.
of
Yeah.
one more. Perfect. All
Okay.
right. So Ron's colleague Dahlia has offered to provide pro bono legal services to the Humane Rescue Alliance in Washington, D.C. May she do this? No, it would be, A is no, it would be consistent with Dahlia's obligations under the rules of professional conduct, but inconsistent with the law. B, no, it does not fulfill Dahlia's objectives under the rules of professional conduct, nor is it consistent with the law. C is yes, pro bono service is consistent with both the rules of professional conduct and the objectives of the DC government. Or D, yes, as long as she is competent to do the work, that is the only standard. All right, we're getting some good votes here. So I saw some D's earlier and some C's.
Oh. Wow. Okay, so this is a little bit of a, I think, kind of trick question, because remember, we're focusing on the Humane Rescue Alliance as being the organization for which the lawyer wants to provide pro bono services. So can we go to the next slide? Everyone here seems to think it's C or D, so maybe Erika and I got this one wrong. Let's talk about that. So we thought the best answer was that it didn't fulfill her objective. It does not fulfill her objectives under RPC, under the rules of professional conduct, nor is it consistent with the law. So let's take the rules of professional conduct first. So in the District of Columbia, we have an aspirational rule with respect to lawyers providing pro bono legal services. And that rule says that a lawyer should participate in serving those persons or groups of persons who are unable to pay all or portions of reasonable attorney's fees, or who are otherwise unable to obtain counsel. And it really focuses again on people who are unable to afford counsel or participating in the work of organizations that provide legal services to them. And so we were really trying to, kind of trip you up a little bit on this one, because I'm sure there are many animal lovers out there. I'm an animal lover. I'm really a dog person. My son has a 90-pound Rottweiler, and we have a pit bull mix, and which we all rescued, and so we're a big rescue organization people. But this particular rule of professional conduct is really about serving people, human people. I think we can make arguments about, well, this is an organization, and so you're really providing the legal services to the people who are doing this work, and And what if animals, some of the animals are service dogs? I mean, I think there are always arguments that can be made. And the great news here under the rules of professional conduct is we don't really have to fight about them because this is not a rule for which you will be disciplined. But it is sort of interesting to look at the purposes of the rule. And if we go into the comments to Rule 6.1, we see that the rule incorporates the legal profession's historical commitment to the principle that all people in society should be able to obtain necessary legal services. So that's really the focus of the DC rule of professional conduct, the ethics rule. And so that's why we said it didn't fulfill our objectives under the RPCs. We also thought that it wasn't particularly consistent with the the new pro bono act that was adopted in DC. Now, I may have this wrong, and Rashee can correct me on this, but this was the act that was adopted in June of 2022, and it amended the 2011 act that allowed district employees to provide pro bono legal services under certain circumstances. And one of those circumstances required that the legal representation be done in affiliation with a covered organization. And a covered organization included a nonprofit organization located in the district that provides legal services to individuals with limited means at no charge or for a nominal fee, other nonprofit organizations that serve individuals with limited means or small businesses located in the District of Columbia, or a law school-based clinical program. So the Humane Society didn't seem to fit into any of those. And so that's why, we took the answer in this particular hypothetical to be, right? I mean, here's the questions. How is a person defined?
Right.
It's not. I mean, it's not. And so we kind of go to, when we're interpreting this rule, we look, the ethics rule at least, we're going to look at sort of the historical purposes for it, the explanation, the explanatory comments, which again talk about serving individuals and individuals' rights. But it's, this is just, it's sort of an interesting thing. Do the RPC of DC fail to align with the majority of state bar associations throughout the US? Well, that's a great question. And our colleague Saul Singer did a Speaking of Ethics column. If you go to the DC Bar website under the legal ethics page and click on Speaking of Ethics, I believe the title of the comment was DC is different. And he sort of goes through every rule of professional conduct where DC sort of takes a different approach. We have the same structure as the model rules and the majority of the jurisdictions in the United States, but there are certain rules where DC takes either a minority position or we're the only jurisdiction in the country that does it a certain way. With respect to Rule 6.1, this is a fairly consistent rule among jurisdictions, although some jurisdictions have actually mandated pro bono work in their jurisdiction. And a jurisdiction, for example, like New York, has a reporting requirement of either how much money you've given within a range or how many hours of work you've done. But it's reported anonymously, which is kind of interesting. They're just trying to get the aggregate numbers in New York. We don't have that in DC.
Right. Yeah.
Rashee,
That
did you
is
want to add to that?
the new pro bono legal representation.
Okay.
That came through to the.
Oh, good. So Rashee provided that. Did you have anything else you wanted to add to that discussion?
My main consideration is your position DC government, representing somebody against DC government.
Right.
That's a big one. Yeah, you can't do that.
Yeah.
Right.
And then again, that's the first thing in this pro bono legal representation. The matter does not involve a claim against the District of Columbia. Like that's the hard no.
Yeah.
Yeah. Is DC considered to be laxer than most? I would not say that. I would not say that DC is considered to be laxer than most, but I don't know what that means with respect to this particular rule or with respect to, we have over 100,000 DC bar members. We have a pretty robust Office of Disciplinary Counsel. I would certainly say that there are rules that the Office of Disciplinary Counsel cares about a lot. Those typically tend to involve client funds, which is maybe not a concern for government lawyers, so that's good for you. But they also care about lawyer honesty, and they care about client confidentiality. So, you know, those are where we really see the Office of Disciplinary Counsel, and where our rules tend to take a primacy over other jurisdictions. Erika, do you have any other thoughts on that?
Well, I just wanted to make the point that, you know, this is not a rule that subjects DC lawyers to disciplinary action, right? Failure to ever do a minute of pro work in your entire career is not going to result in you getting investigated. You know, it can't. This is it's an aspirational rule, and certainly it's an important and the DC bar is, you know, so very, very supportive of lawyers doing pro bono work that directly aligns with this rule. And also, you know, again, Humane Rescue Alliance, you know, you're not going to find anybody who is going to criticize a lawyer for devoting their hours to an organization like that. So sometimes I think of funny hypotheticals. If I could come up with some sort of organization that had their lawyers do, you know, 100 hours of each of pro bono work for an organization that was not covered by the rule and perhaps was very politically oriented or something, right? And then they claimed pro bono credit or submitted all of those hours. I wonder if that gets into lawyer trustworthiness or honesty or fitness. But that's the most extreme example I could come up with, and I have to strain to do that.
Okay, well, let's move on because our time is ticking away.
All right.
I think we covered all this slide. So the next. Okay.
All right, so I'll go ahead and get us into this one. So Alicia is a staff attorney for the DC Alcoholic Beverage Administration. Her cousin Jimmy has asked Alicia to help him incorporate a medical marijuana business in Maryland. Under what circumstances can she help him? A, she cannot help him. B, she can help him if Maryland's laws on medical marijuana are consistent with DC's laws. C, she can help him so long as she does not inhale. Or D, she can help him if the DC Alcoholic Beverage Administration consents to the representation. All right, let's see some letters in the chat. Lots of D's here. A B. There's an A. So I think I saw at least a couple A's. This is great. We're getting them. They're all over the here, Hope.
Yeah, they're all over the map. And this, you know, I mean, this is really an interesting area of discussion in the legal ethics world because, you know, the tides are changing and have been changing for a while. And as you know, as recently as last week, there were pronouncements from high levels of our government about what's going on here. But the answer as of today in the District of Columbia is A, she cannot help him. So let's talk about why that is under the DC Rules of Professional Conduct. Next slide, please. The reason is that the sale and use of marijuana, while it's legal for medicinal purposes in the vast majority of jurisdictions, and it's legal to some extent for recreational purposes in many jurisdictions, including the District of Columbia, the sale and use of marijuana is illegal under federal law. It remains so, notwithstanding that large swaths of people were pardoned for federal crimes last week, and notwithstanding that the current administration has asked the Food and Drug Administration to look at reclassifying. For now, the law is the law. And when we're looking at the ethics rules in this particular hypothetical, what we were being asked is, can she help him, you know, legally? Can she provide legal services with respect to setting up this business or regulating this business or the like? And right now we have a rule in the District of Columbia. It is the model rule. The model rule is 1.2D as in David. Ours is 1.2E as in Edward, but it's effectively the same rule. And it's a rule that exists in the vast majority, if not all jurisdictions, that says that a lawyer shall not counsel a client to engage or assist a client in conduct the lawyer knows is criminal or fraudulent, but a lawyer may discuss the legal consequences of any proposed course of conduct with a client and may counsel or assist a client to make a good faith effort to determine the validity, scope, meaning, or application of the law. So we have this really weird circumstance when we're dealing with giving legal advice on marijuana, where we have state laws that are in contradiction to federal laws. And it's a problem for lawyers. And frankly, it's a problem actually for states in that they want lawyers to be assisting these entities setting up and people who want to engage in these businesses because they tend to be highly regulated. When they approve these laws, they tend to be highly regulated, the way they want the dispensaries to be regulated and the like. And so having lawyers involved from a public policy perspective makes a heck of a lot of sense. But for lawyers, frankly, there's always going to be a risk. Now, the reality is that there are lawyers engaged in this work. They're engaged in this work in jurisdictions where the disciplinary system, and I'll say Washington State and Colorado are among those jurisdictions, as is expected, where the lawyer disciplinary system has either changed the rules of professional conduct or the disciplinary offices have issued memorandums of understanding saying, we are not going to prosecute lawyers under Rule 1.2D or 8.4, which is engaging in criminal conduct, for advising clients on the state law. But what lawyers have to do is always advise the client that the federal law at any moment could sort of come in and supersede. And so that's how it's handled. And then in other jurisdictions, lawyers have just decided to take the risk. They decided to take the risk that, you know, it's legal in this state, I'm going to advise the client on, and they do it. But in terms of what is the answer and what you would get from us at the Legal Ethics Helpline, because we're always trying to help lawyers keep their licenses and avoid any sort of disciplinary investigation or activity, we're going to tell you the rule, the plain language of the rule says what it says, and it's still a problem.
Right.
Okay, about lawyers that work on the medical marijuana program. Yeah, you know, the ones that work, is this a government? I'm sorry for my ignorance on that. Is this a government, right? I mean, they're working on.
Right. I think it's pretty protective, you know, a lawyer who's literally working in the service of their government, which has said, we need you to do this work to enact one of our laws or regulate, you know, a product that we needs to be regulated. That's pretty protective of the lawyer, right? Even if the federal government's going to say, well, we're not entirely on board. So
yeah. I can't see a single disciplinary counsel going after any of those lawyers. So we have sort of the, you know, how do we analyze the rule and what's the answer under the rule? And then what's the answer as it would actually play out in practice? So I think those lawyers. Let's go to the next slide though. Let's get into this a little bit more. So New Jersey issued an opinion about 2 weeks ago. It's opinion 744. They're not the only jurisdiction that looks at this other question. This question of whether the New Jersey lawyer could use regulated marijuana, or could they operate or invest in a regulated marijuana business? And their opinion came out and said, yeah, you can do it. It's not a violation of 8.4B. Which is the rule that says it's professional misconduct for a lawyer to commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. They said, you know, it may be a criminal act technically still under the federal law, but it certainly doesn't reflect adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer because it's legal in New Jersey. So that's sort of the approach they took. I mean, what's interesting is they didn't touch Rule 1.2E. And I think that's because that's sort of a tricky one to get around. It's okay to be able to say that a criminal act doesn't reflect adversely on the lawyer's honesty, trustworthiness, or fitness. but it's harder to say it's not a criminal act when we have the federal law as it stands today. But New Jersey isn't the only jurisdiction that has an opinion around this question of use. I think New York does, Washington State, Colorado, maybe Connecticut is another jurisdiction. There are a handful of jurisdictions that have similar ethics opinions. All right, next question, please.
All right. So if I'm a New Jersey lawyer, in addition to being a DC lawyer, does this mean I can ethically use marijuana? A, no, because DC rules always apply to DC lawyers. B, yes, because marijuana use has been decriminalized. C, no, because DC has not released guidance equivalent to New Jersey's opinion. Or D, maybe, but only if your principal place of practice is in New Jersey and you stay there. Let's see. Got some good A's. There's a C.
Okay, so I'm gonna, thanks for participating. It looks like no, because the DC rules always apply to DC lawyers. Well, that's sort of a trick question, because while it's true that the DC rules are always going to apply to you with respect to some rules, right? The 8.4 rules, for example, a former disciplinary counsel, Gene Shipp, used to wear his pink hat. He put the pink hat on, says you're admitted to the DC bar. He puts the pink hat on, he says, and you never take off your pink hat. And that was really talking about the 8.4 rule. That's, you know, a lawyer shall not engage in criminal conduct rule that reflects adversely on the honesty, trustworthiness of the lawyer. But because lawyers are multi-jurisdictional and we do travel around, there are other rules in DC that also, I mean, that's actually, now that I'm thinking about that, I'm going to talk myself maybe out of that, except for the real answer here that we've tried to get into this from an 8.5 perspective. So let's go to the next rule. We said the best answer was D, but only if your principal place of practice is in New Jersey and you stay there. And here's why. Can we go to the next slide, please? So choice of law, this is where we try and figure out whose rules a lawyer's subject to. And the main rule that normally comes into play with lawyers and the rules of professional conduct is 8.5 B1, which basically says for conduct in connection with the matter pending before a tribunal, the ethics rules to be applied to the lawyer's conduct will be the rules of the jurisdiction in which the tribunal sits. So that's a clear example where the lawyer's rules of professional conduct that they're going to be subject to will be the jurisdiction where the court is. So for example, if you, DC, New Jersey lawyer, are in a New Jersey court representing a client, you are no longer subject to the DC rules of professional conduct with respect to that case. All of the ethics rules from New Jersey are going to apply to your conduct in that case. But this isn't before a tribunal. We're talking about personal behavior. So how do we analyze that? Well, the 8.5(2) goes on to say that if a lawyer, for any other conduct that's not before a court or in connection with the a case pending before a tribunal, if the lawyer's licensed to practice in this and another jurisdiction, the rules to be applied shall be the rules of the admitting jurisdiction in which the lawyer principally practices. So that was the answer in D. The New Jersey DC lawyer principally practiced in New Jersey. Provided, however, that if particular conduct clearly has its predominant effect in another jurisdiction in which the lawyer is licensed to practice, the rules of that jurisdiction shall be applied to that conduct. So that's why we said you had to stay in New Jersey. Because if you were principally practicing in New Jersey, right, but you went to DC for a DC matter and you were smoking marijuana in DC, then the conduct would then apply the DC rules to your conduct. So that's kind of a fun way to work through choice of law analysis, which can be complicated. For those of you who principally practice in DC for the DC government and stay in DC courts and in DC generally, you don't have to worry about this rule. You're subject to the DC rules. But the bad news is, from an ethical perspective, under the rules at least, you can't engage in smoking of marijuana. Okay, next slide, please. And so why don't we have the guidance on this? I mean, I think, you know, I'll sort of give you a little bit of inside baseball that both the Rules of Professional Conduct Review Committee and the Legal Ethics Committee sort of, at least a few years ago, started looking at this issue and decided this was one that probably was better left untouched. We're not seeing a lot of prosecutions in the Office of Disciplinary Counsel. I'm not even sure that I've seen any. Now, where I would say lawyers really need to be careful as they would as they would whether they were just imbibing alcohol is dealing with impaired driving, because that's an issue that ODC does care about. Whether you're impaired from use of marijuana or you're impaired from use of alcohol, that is a conduct that can have disciplinary consequences. You know, the first conviction for DUI, typically from the Office of Disciplinary Counsel, as long as there aren't other offenses tied to it, and the person is sort of cooperating with any probationary terms and the like, you usually aren't going to see any public discipline. When you start seeing multiple impairment actions against a lawyer, that's when disciplinary counsel is going to move in and ask for something more serious. So, Rashee, do we have a government ethics approach to marijuana use?
I guess same. We have the DPM 1800.3M, which you are required to do federal, state, and some jobs explicitly tell you you cannot. You know, so like police officers, you can't.
Interesting.
Like you said, I don't know that there's like a huge posse of enforcement on this, right? Like going around in the night picking up people.
Right. No, I don't think that's happening, but yeah. So, all right. Well, it looks like we didn't get to all of our hypos. We're never sure, you know, how many.
Right.
You know, last minute questions for us.
You know, we're supposed to give a code out.
Oh,
Oh,
we were.
let me give me a minute.
Yeah, we need to give you a CLE code.
Yep. And on one moment. Sorry, guys, I'm just making sure. I find the code. Okay, it is CL81. And
Put that in the chat.
I'm gonna put it in the chat. I'll hide it. I'll put it up here as well.
CL81.
Yeah. Sorry, I'm not going to CL81. I'm not sure that works very well. That's right. So you might be asked for that code. Now I'm trying to think if there's we might have some paperwork that we need to send you that would go out to participants as well, Rashee, or you might have.
I think I have, is it the, there's like a PDF on obtaining CLE credit.
Right, exactly.
Mm-hmm.
Yeah, we can get this out to attendees.
All right, excellent.
Well, thank you all. Thanks for your participation. Have a great weekend.
That's right. Bye, everyone.